Today I want to talk about what's in David Cameron's baskets. In other words, what's in the UK's deal with the EU. And I'd like to start by thinking about why are we where we are. And as you probably know, there's been a long history of infighting in both of the main political parties about whether we should stay in the EU or not, whether we're losing too much sovereignty of Parliament to Brussels, the European Union institutions. And eventually, in 2012, in David Cameron's Bloomberg speech, he committed the Conservatives to having an in-out referendum if the Conservatives won the election in 2015, which they duly did. And in his 2015 November speech, he set out the sorts of things that he would like to have as part of an agreement with the European Union before he would commit himself to taking a remain or leave position in the European Union. And he said he had 4 objectives, which I will briefly go through because they have structured the nature of the renegotiation. So first of all, to protect the single market for Britain and for those states which are outside the Eurozone. Secondly, he wanted to make competitiveness as part of the DNA of the whole European Union, and this includes cutting the total burden on business. Thirdly, he wanted to exempt Britain from an ever closer union and also bolster the roles of national parliaments. And fourthly, he wanted to tackle abuses of the right to free movement and to enable the United Kingdom to control migration from the European Union in line with its manifesto commitment. And then he concludes that if he has an agreement with the EU, it's got to be on the basis that it is legally binding and irreversible and, where necessary, has the force of the treaties. So that was the framework for the negotiations that followed. There was an intense period of negotiations leading up to early February when the draft text was published, and then some fairly tortuous negotiations at the European Council on the 18th and 19th of February. And we now have a text which David Cameron feels is a good enough deal for the United Kingdom, so he will fight and campaign to remain in the EU, and there will be a referendum taking place on the 23rd of June 2016. So what about this deal? Is it just one single document, or is it more than that? In fact, it's actually a rather complicated deal. It really takes 4 main forms. First of all, there is a decision of the heads of state or government meeting within the European Council concerning a new settlement for the United Kingdom. Now, this is the main document, and I will refer to it as the UK decision. And this document is legally binding, and it has the force of international law, not EU law, and it's going to be registered as such. Now, it's not the first time this mechanism's been used. It was also done to keep the Danes on board when they were having problems with the EU, and also the Irish when they were having concerns about the Lisbon Treaty. And so this particular document can't be altered without the consent of the United Kingdom. So that's the first and main document. Then there is also a statement containing a draft council decision on the management of banking union and also on the euro area. And when that takes effect, that will be part of EU law. Thirdly, there are a number of declarations fleshing out some of the points in the UK decision. And fourthly, the UK decision refers to the fact that there will be new laws on free movement, and that requires amendments to existing EU regulations and directives. Now, all of this will only take effect once if there is a Remain vote. If there is no Remain vote, then this deal does not come into force. Now, I think it's worth noting that although this is seen as a special deal for the UK, some of the changes will have an effect right across the EU. But the opening paragraphs of the UK decision, that's the main decision that was entered into, already notes just how special the UK is. The UK has already got the opt-out from the single currency, or in particular, it's under no obligation to adopt the single currency and to keep the pound sterling. It doesn't participate in the Schengen acquis, and the Schengen acquis is the acquis about borderless travel within the Schengen states. It also can choose whether or not to participate in the area of freedom, security and justice. And also a lot of criminal law doesn't apply to the UK unless we decide to opt into it. And finally, there is the VEX protocol on the Charter, Protocol 30, which was widely regarded as an opt-out from the Charter, although that has been contested by the Court of Justice. So the UK is already special, but this deal makes us even more special. Now, if you recall, we said that David Cameron identified 4 areas of negotiations, and those 4 areas are the 4 areas in which the UK deal has been structured around, and they are often referred to as baskets. And I will look at those, each basket in turn. And the first basket is called the economic governance basket, and this is the basket intended to deal with David Cameron's concerns about the fact that the UK might be put at a disadvantage by the Eurozone states because the UK does not use the single currency. This basket is also intended to address his concerns about so-called caucusing. And caucusing is where if there is a single market issue, then the Eurogroup might meet and decide the position they're going to take collectively, and the UK doesn't have any say because it doesn't participate in the Eurogroup discussions. And then it gets forced through against the will of the minority of states who are not Eurozone members. More generally, David Cameron's concerned about Eurozone states forcing through legislation that discriminates directly or indirectly against states that don't subscribe to the euro. So what do we have in his basket? Well, first of all, a general commitment to mutual understanding on both sides, that the non-Eurozone states need to appreciate that the Eurozone needs to deepen still further, and that they should not obstruct that further deepening, but conversely, that the process will respect the rights and competences of the non-member states. Secondly, there is a commitment to no discrimination to deal with David Cameron's concerns about discrimination. The UK decision makes clear that discrimination based on a country's currency is banned, and any difference in treatment must be based on a good reason. And furthermore, laws in the Eurozone area must respect the single market, which is what David Cameron sees as the core of the EU project, at least for the non-Eurozone states. And then there are specific provisions on banking union. David Cameron was concerned too that EU institutions with power over banking law could dictate to banks in non-Euro states. Now, he hoped he would get a veto. In fact, he didn't get the veto, but what he does get is that states not participating in the banking union can indicate their opposition to some proposed laws. And then the draft decision, that's the second measure I mentioned before, lays down the process for reaching agreement in that situation. But it does make clear that the plans cannot result in a situation which would amount to allowing a member state a veto. And finally, there's also a commitment in this basket that in the case of emergency and crisis measures designed to safeguard the financial stability of the euro, this will not entail a budgetary responsibility for states like the UK, which are not in the Eurozone. So that's the first basket. The second basket is the competitiveness basket. And this is perhaps the least controversial and for our purposes probably the least interesting. It's basically a basket of motherhood and apple pie. It's a basket which says that the establishment of the internal market, that's where you've got free movement of goods, persons, services and capital, is an essential objective of the Union. But when member states are acting as legislators in the Council and European Parliament, there should be a conscious effort to lower administrative burdens and compliance costs. Now, this ties up with the EU's better regulation package. It's a long-established commitment of the EU. It obviously dovetails very well with the UK's agenda, and it has now got a commitment, at least in international law, that that's what the EU should be focusing on. The third basket is on sovereignty, and there are two main limbs to this basket. One concerns the vexed question of the phrase ever closer union, and the second concerns the so-called red card procedure. As far as ever closer union is concerned, that phrase has been in the treaty since the beginning. Now, contrary to popular belief, it doesn't say ever closer union amongst the states, but it merely says ever closer union among the peoples of the Union. It's been in the treaty since 1957, and the UK has signed up to this when it acceded to the EU and implicitly with each other subsequent treaty amendment. However, David Cameron said very clearly in early February that we do not want to have our country bound up in an ever closer political union in Europe, i.e. progress towards a federal or superstate. Now, a lot of people say that's not what the treaty commitment was, but that is how it is perceived. So what did he get? In the final deal adopted on the 18th and 19th of February, he has got an agreement that there will be a treaty amendment in the future, so it's a bit like a post-dated cheque, to make clear that the references to ever closer union do not apply to the United Kingdom. And then the text goes on a bit further, and it says the references to an ever closer union among the peoples are therefore compatible with different paths of integration being available for different member states and do not compel all member states to aim for a common destination. So it's clearly stating that there are different speeds and we are not all headed to some particular goal of some superstate. Some states will be proceeding at different rates. And indeed, as the text has already made clear, the UK is already in a very special position with the large number of opt-outs that it already enjoys. So that's ever closer union. Will it make a difference? Probably not a huge difference, because although the Court of Justice has referred to the phrase on a number of occasions, it's never really been crucial in the outcome of any particular judgment. So it's much more a political statement than a legal one. The other aspect of this sovereignty basket concerns subsidiarity. And as you know, subsidiarity means that decisions should be taken as close to those affected as possible. And the principle of subsidiarity has been in the treaty since Maastricht in 1992. And subsequently, in order to try and make sure that the subsidiarity principle was properly respected, the Lisbon Treaty in 2009 introduced the so-called yellow and orange card procedure. Now, the orange card has never been used, but the yellow card has. And under the yellow card procedure, 10 out of 28 national parliaments can ask the Commission to reconsider a proposed law if those national parliaments think that there is a subsidiarity problem. In other words, the EU shouldn't have been acting, that they, the member states, should have been acting instead. And if the Commission gets one of these so-called yellow cards, it has to reconsider the measure, but it can go ahead anyway. And on one occasion, it did withdraw the measure, although it protested that this wasn't on subsidiarity grounds. In the other case, it did indeed go ahead. Now, what David Cameron wanted was a total veto. He wanted national parliaments to be able to put their foot down and say, we don't agree with these measures. They shouldn't be done by the EU. They should be done by the member states. And so, therefore, he wanted a red card, essentially, to send off those national measures. In fact, he didn't really quite get that. I mean, what he got, it's called the red card procedure. I'd say it's more pinkish than red. And that's because under the new arrangements, if national parliaments are concerned about subsidiarity, and those national parliaments represent more than 55% of the votes allocated to national parliaments, in other words, 16 or more national parliaments, then that triggers a process. And the process is that the council presidency will put the item on the council's agenda for a comprehensive discussion. Note, no language of stopping the measure, a comprehensive discussion. And then the council will discontinue the consideration of the draft legislative act unless the draft is amended to accommodate the concerns expressed in the recent opinions. In other words, there will be discussions. If the concerns can't be dealt with, the draft measure will be put on hold. It's not abandoned entirely. And the council itself will be the judge whether the national concerns have been accommodated. So it helps, but it probably doesn't make a huge difference because the voting rules, the pre-existing voting rules, probably could deliver this outcome if sufficient member states were opposed to the measure. One smaller thing that he did get through, which might help in the longer run, is he also did get a clear statement that EU action should only be taken where there is a transnational element to the issue. In other words, there's got to be a rule which has an effect on interstate relations. And this is quite an important statement. It's something that had been understood, perhaps, but had not always been applied in practice. So that actually may, in fact, prove more significant than his red card. This brings me to the final and the most controversial basket, and it's the basket which has had most attention in the press, and that's the basket on free movement of persons. Now, there is, as you know, a strong perception in the UK that there has been too much migration in the UK, and that one of the pull factors attracting people to the UK is the level of benefits. And certainly the government has argued that 40% of EU migrants claim in-work or out-of-work benefits. So in-work benefits are benefits like tax credits, housing benefit, and out-of-work benefits, obviously job seekers allowance and equivalent. Now, that figure is contested, as is the idea that migrants are a drain on our system. One of the best respected studies by Dustman and Frattini for UCL in 2014 says that actually migrants are net contributors to the UK, and I quote, they say, migrants are paid more in taxes than they received in benefits, helping to relieve the fiscal burden on UK-born workers and contributing to the finance of public services. Nevertheless, the perception is there, and David Cameron was determined to try to deal with that perception. So you have the basket on free movement of persons, and it opens with a clear statement that there is a right to free movement of workers. So anyone who's an employee can come to the UK to work in the UK, and once they are here, they will enjoy equal treatment in respect of social advantages, benefits, and tax advantages, tax credits. But the basket begins by noting some of the problems that the UK has experienced. In particular, it notes that differences in rates of pay between member states has been a pull factor. And certainly, if you look at minimum wages in Poland, about €409 a month, Romania, €217 a month, in the UK, €1,378 a month for people working full-time. So there is obviously a pull factor in terms of rates of pay. And furthermore, the argument is that there's a pull factor in terms of the different social security systems. The UK system is in part universalist, which means that if you're poor, you get the benefit. You don't have to contribute prior to getting that benefit. Crudely speaking, a number of the continental systems require prior contribution. And so that's one of the reasons why the argument goes that the UK is seen as an attractive venue for migrant workers. David Cameron was also concerned not just about social security, but also abuse of the free movement system. He has been worried about sham marriages, as well as the fact that it's easier for an EU citizen to bring a non-EU spouse to the UK than it is for a British citizen to do the same. Now, it's this context which explains the nature of the deal. Now, this is quite a complex package of measures, and I want to briefly refer to the 5 main areas where the deal was agreed. First of all, benefit tourists. David Cameron, has been worried that people come here to the United Kingdom particularly to seek benefits. Now, there's been an important decision of the Court of Justice in a case called Dano prior to the renegotiation. And Dano had made clear that if someone had moved from one state to another, in that case from Romania to Germany, and had nothing to support themselves on, they weren't working and they didn't have sufficient resources for themselves, they couldn't use the citizenship provisions of the treaty to entitle them to benefits. If they didn't have sufficient resources, they could not claim benefits. And that decision was enshrined in the UK decision. Secondly, the UK decision also refers to the position of job seekers and makes clear that job seekers will not be entitled to minimum subsistent costs when they are looking for work in the United Kingdom. That brings me on to the 2 big ticket items that have had quite a lot of attention. The first one is about exportability of child benefit. Now, Article 67 of the Social Security Regulation, Regulation 883/2004, allows workers working in the UK to send child benefit back to their children in, for example, Poland. And David Cameron has said that this is a misuse of the benefit system. In fact, the levels of remittances in the form of child benefit to other states is tiny compared to the levels of child benefit paid to those resident in the UK. Nevertheless, David Cameron wanted to put a stop to that. In fact, he didn't get that. What he got instead was the option to index such benefits to the conditions of the member state where the child resides. So, given that Poland has lower standard of living than the United Kingdom, the benefit would be indexed to the standard of living in Poland, and so they would get less benefit than if the child was in the United Kingdom. Now, the UK deal says this applies only to new claims made by EU workers, so it will only apply to those arriving in the UK, but from the 1st of January 2020, it will also apply to those already getting child benefit in the UK. Now, the Commission is going to make a legislative proposal on this, how this will work, as soon as the UK decision comes into force, which of course is dependent on a vote to remain. The other big ticket item is a so-called emergency break. Now, as I've already said, in respect of migrant workers coming to the UK under Article 45, they're entitled to equal treatment in respect of social advantages and tax advantages. Now, David Cameron wanted a total ban on in-work benefits, so things like tax credit, for 4 years. Now, this is clearly discriminatory and contrary to the equal treatment principle. He didn't actually get his 4-year ban, but what he got instead was the emergency break. That's the colloquial name. It's properly known as the alert and safeguard mechanism, but I'll call it the emergency break. And even the emergency break is somewhat misleading because break suggests that there is a total stop on getting in-work benefits, and that's actually not the case. In fact, what it is that if a member state can show that they are suffering from a situation where there's an inflow of workers from other member states of an exceptional magnitude over an extended period of time, and that inflow of workers has affected the essential aspects of the social security system, or has led to serious difficulties in the employment market, or is putting excessive pressure on the public services in that state, then that state can notify the Council and the Commission, and then the Council can make a decision to authorise the member state to restrict access of newly arriving EU workers to non-contributory in-work benefits for a total period of 4 years from the commencement of employment. Now, that sounds quite complicated, but basically it allows the Council to authorise the UK to stop newly arriving workers from receiving in-work benefits. But it's not a total ban for 4 years. They get nothing at the beginning, but the longer they work, the more benefits they're entitled to. So it's a graduated approach to benefits. And the authorisation will last for 7 years. Now, this emergency brake requires an amendment to an existing EU secondary law, an existing regulation 492/11, and the Commission is going to put forward a proposal once the UK votes to remain, if it does decide to do so. And then, of course, the process needs to be applied for. So the UK needs to write to the Commission to say that it finds itself in this exceptional situation. Helpfully for the UK, in a declaration appended to the decision, it says that the European Commission considers that the kind of information provided to it by the UK, in particular because the UK didn't make use of transitional arrangements in 2004, when the EU8 states acceded to the European Union, shows that the type of exceptional situation that the proposed emergency brake is intended to cover already exists in the United Kingdom. Now, there is so much which is contested about that. One, there's no evidence has been produced to show that we are in this crisis situation. Secondly, even if the Commission does propose this measure, there's no guarantee that the Parliament will vote to approve it. And there's also no guarantee that the Court of Justice will accept that the introduction of discrimination against those who are working, remember this is in-work benefits, not out-of-work benefits, will be compatible with the treaty, Article 45. And some of the commentators think this is the most vulnerable bit of the deal. So the remainder of the free movement basket deals with David Cameron's concerns about abuse of free movement. And in that part of the basket, you will find commitments to tackling marriages of convenience, to addressing the so-called Surinder Singh issue, which involves EU nationals and getting married to so-called third country national spouses in another EU state, and whether they can bring their spouse back to the UK, and also requiring third country nationals to have been resident in an EU state before they can invoke EU rights as the spouse of a migrant. And also there has been some proposals to make it easier to deport EU nationals where they are likely to constitute a threat to public security, so just lowering the threshold somewhat. So those are his 4 baskets. What does it mean? Is it going to make a big difference? Well, David Cameron clearly thinks it does make a big difference because he has committed himself to campaigning to remain in the European Union. Obviously, the Leave campaign don't think that the deal has gone far enough. I think it's hard to say that the deal has made a fundamental change to the UK's relationship with the EU. But I think we can say that some of the individual aspects of the deal, particularly in the fourth basket, the basket on free movement of persons, will be important to many people in the EU and will change their lives in ways that they had not expected.